Right, good afternoon everybody out there. Welcome to the Brave New World, Commercial Litigators Guide to the New Insolvency Act. I prefer to call this Insolvency in Times of Plague, because that's the sort of time we're in. In fact, this isn't the first time that governments have responded to national crises. There's a history of emergency insolvency legislation passed in both the First and Second World Wars, but specifically to deal with wartime emergencies. This particular act that we're going to be discussing today, the Corporate Insolvency and Governance Act, is not, as I'm sure you all know by now, just a response to the current crisis. It's been used to graft on new regimes into what some of you may feel is already an overcrowded insolvency market, that provides a great deal of protection to creditors, whilst doing to debtors, whilst doing perhaps rather less for creditors, except perhaps the inland revenue. So to answer questions such as what can be achieved with this new moratorium, what can we do with it that we couldn't do anyhow using administrations, why do we have to talk about cram down now instead of the good old English statutory binding, and what's going to happen when a winding up petition is declared void, are questions that will be addressed by three learned and distinguished members of Quadrant Chambers. Jeremy Richmond, QC, this is the token man on the panel for the evening, is, apart from being an English barrister, admitted to the New York bar, and is actually, as I understand it, practiced as a US lawyer. I can vouch from personal experience that he's a formidable advocate, but his experience includes not just insolvency, but a wide spectrum of commercial work, with a penchant for asset recovery and cross-border litigation. And he will shortly be talking to us about the ipso facto provisions in the new Act. Nicola Alsop is one of those people one's always pleased to see in court. I know her from her extensive insolvency practice, but she too has a wide experience of commercial litigation, both national and international. She's called to the BVI bar, as well as the English bar. And she's going to talk to us on the provisions dealing with the suspension of statutory demands and winding up petitions. Emily Saunderson, the third member of the panel, is a commercial litigator who specialises in commercial law, fraud and banking. Looking her up, I see she's had the doubtful pleasure of appearing recently, I hope I've got this right, in a case called Sheffield United versus UTB, all about privilege, and that exciting disclosure pilot that's going on. I haven't bothered to read it in full because I'm sure I wouldn't understand it. We're not going to hear about her from her about that today. She's going to be talking about the new moratorium. Before I hand over to the speakers, could I just ask everybody to make sure your microphones are muted and your videos turned off so the system doesn't overload and explode. We have a huge number of participants. And if you've got any questions, I hope you have about 10 or 15 minutes at the end. Could you use the Q&A function on your screen? We'll pick them up. So without any more from me, over, Emily, to you to go first.
Well, thank you very much. Let me just start sharing my slides with you. There we go. Thank you again for the introduction. I'm going to be talking to you about the new moratorium provisions that have been introduced into the Insolvency Act by this new Corporate Insolvency and Governance Act. Now, as I'm sure you're aware, these provisions are supposed to provide some breathing space for companies while the directors remain in place, and they try and save the company as a going concern. And just to give you a roadmap of where I'm going with this talk, when I started looking at the new legislation, there were 5 questions that I thought I needed the answers to. So that's the order in which I'm going to address them, is the 5 questions that occurred to me. Firstly, what is this new moratorium? Secondly, how do you go about obtaining one if you're a company that wants to get a little bit of breathing space to get you out of a jam? How long does it last? The real meat of the issue, what are the effects of this moratorium? What do you achieve by getting a moratorium in place? And finally, how does it end? Now, before I get into the detail, I just want to give you a little bit of a health warning. the Corporate Insolvency and Governance Act, CIGA, is a bit of a monster when it comes to legislation. It runs to 245 pages. And my experience of trying to find my way around it is it's a little bit difficult. So things are not necessarily where you think they're going to be. There's a lot of exposition in the schedules. And my top tip for dealing with it, if you've got a bit of legal research you need to do, is get yourself a word searchable version of the legislation and do some intelligent word searching to just make sure you haven't missed any relevant provisions. So what I'm about to give you is very much an overview. I would encourage you to go and have a look at it if you've got a difficult question. So that said, let's move on to the first question. What is this new moratorium? Well, it's an entirely new procedure that's been inserted into the Insolvency Act as new Part A1. So it comes right at the start of the Insolvency Act. It applies to eligible companies, and the definition of eligible companies is found in Schedule ZA1. Well, I'll explain to you a little bit more about eligible companies later. One of the key factors is that the directors stay in place, and you have a licensed insolvency practitioner who is appointed as the monitor, and the job of the monitor is just to monitor that the moratorium is producing the effect that it's supposed to produce, which is essentially to keep the company going, keep the company operating as a going concern. One of the key features is that the company gets a payment holiday for certain pre-moratorium debts. I'm going to explain to you later what a pre-moratorium debt is. Unsurprisingly, it prevents certain enforcement action, including winding up by creditors. And crucially, it changes the payment priorities in any subsequent liquidation or administration. I should note that there were two previous moratoriums available under the Insolvency Act. One was under Schedule A1, and that came into play ahead of a company voluntary arrangement. And that sort of moratorium is no longer available. Those provisions have all been repealed by this new act. The second is a moratorium that arises when a company files a notice of intention to appoint an administrator, and that's still available, that moratorium. The difference with this new moratorium is supposed to be that the directors remain in place. So it's very much a corporate rescue sort of halfway house between a more informal insolvency procedure and no insolvency procedure at all. And the legislation has been on the blocks for some time. The current pandemic is the reason that it's been rushed through Parliament. But even as far back as April 2016, the R3, the Association of Business Recovery Professionals, was saying that there needed to be something more akin to Chapter 11 in the US in English insolvency legislation, which allowed the directors to remain in charge of the company, to give it more options in terms of maintaining the company as a going concern. So let's just run through how you go about obtaining one and whether you're eligible or not. The first question is, can you obtain one? And as I said, Schedule ZA1 sets out eligibility, and it sets it out in a negative way. It sets out the exceptions to whether a company, to being an eligible company. And there are 14 categories of exclusion. I've attempted to summarize them into 3 categories here. The first one is that if the company has been in an insolvency procedure in the previous 12 months, then it's not eligible to apply for a moratorium or to get a moratorium. There is an exception to this exception, and it's temporary. Before the end of September this year, if a company is subject to a winding up petition, it can still be eligible for the moratorium. Then there is this huge group of companies. There are 13 categories, and they are generally finance companies or companies operating in the financial markets, and they are not eligible for the new moratorium procedure. They're insurance companies, banks, payment institutions, regulated exchanges, parties to capital market arrangements. They are all set out in great detail in Schedule ZA1. And finally, certain overseas companies can't apply aren't eligible for the new moratorium. And they are basically the overseas companies that operate in the previous bullet point. So they operate in financial markets. But assuming you're eligible, how do you go about obtaining a moratorium? Well, if you're an English and Welsh company, it's just a paper exercise. You file relevant documents at court, and that puts you into this moratorium. After the end of September, if you're an eligible company and you are subject to a winding up petition, you can apply to the court for a moratorium. Again, you have to produce the relevant documents. And directors of overseas companies can also apply to the court for a moratorium, and the court has got a discretion about whether it will order the moratorium or not. And the test it's going to apply is whether there's a sufficient connection with England and Wales. So it's the same test as a court will apply in terms of winding up order for a foreign company. And a sufficient connection is probably going to be something like the company holds a debt that's subject to English and Welsh law, or it might be that it has English and Welsh creditors. In all of those situations, though, the company has to produce the relevant documents. So what are the relevant documents? Well, they're set out in the new section A6 to the Insolvency Act, and there are basically 5 categories. Firstly, there's a notice that the directors want to obtain a moratorium. Then you need a statement from the proposed monitor. So you've got a licensed insolvency practitioner chosen by the directors who is going to be the monitor. This person has to produce a statement that they're qualified, willing to act, and that the company is eligible. Then you need a statement from the directors that, in their view, the company is likely to become unable to pay its debts. And you also need a statement from the proposed monitor that, in his or her view, it's likely the moratorium is going to result in the rescue of a company as a going concern. Now, until the end of September, the monitor can also say that it would result in the rescue of a company as a going concern, but for any reasons relating to COVID-19. So the moratorium will come into effect if it's a paper-based exercise. It will come into effect when the documents are filed at court. If you have to apply to the court, it comes into effect when the court makes an order. And once the directors have got the moratorium, they have to inform the monitor, and the monitor then informs Companies House and informs the creditors that he or she is aware of that the moratorium is in place. So how long does the moratorium last? Well, the initial period is 20 business days, starting on the business day after the moratorium comes into effect. So the initial period is relatively short. And the company's directors can extend that by another 20 days without creditor consent, subject to certain debts being paid and further statements from the directors and monitors being filed at court. So you've got a maximum of 20 business days without you having to consult the creditors or anything like that. If the directors do consult the creditors and get creditor consent, they can extend the moratorium by up to 12 months. And creditor consent means consent by majority in value of unsecured and secured pre-moratorium creditors. And I'll explain the difference between pre-moratorium and moratorium creditors in a moment. The directors can also apply to court to get an extension of the moratorium period, and it doesn't look like there's any time limit on the extension. But I would expect that the court will need to be persuaded that the moratorium is actually serving its purpose if the company or the directors are going to apply to extend it for any significant length of time. So let's get to the meat of the issue. What is the effect of a moratorium? Well, to really understand the effects, you have to know what the difference is between a pre-moratorium debt and a moratorium debt. So let's start with that. And these are defined in section A53 of the Insolvency Act as inserted by CIGA. And I'm just going to set the definitions out on the screen because they're very important definitions. A pre-moratorium debt is any debt or liability that the company becomes subject to before the moratorium comes into force. That's intuitive. Or any debt or liability the company becomes or has become or may become subject to during the moratorium by reason of any obligation incurred before the moratorium comes into force. So you can come up with a pre-moratorium debt can be something that occurs during the moratorium as long as the liability was incurred before the moratorium started. A moratorium debt is perhaps slightly more intuitive. It's any debt or liability the company becomes subject to during the moratorium, other than by reason of an obligation incurred before the moratorium came into force, or any debt or other liability the company becomes subject to after the end of the moratorium because of an obligation incurred during the moratorium. So you've got pre-moratorium debts and moratorium debts. And the key effect of this moratorium is the company gets a holiday, payment holiday in respect of pre-moratorium debts. So for the duration of the moratorium, it does not have to pay the pre-moratorium debts. But there are some very important exclusions to those. So debts that become pre-moratorium debts that the company does have to pay. And those are set out in the new section A18, and there are 6 of them. Firstly, the company has to pay the monitor's remuneration or expenses. That's hardly a surprise. The company has to pay for goods or services it receives during the moratorium. It has to pay rent in respect of a period during the moratorium. It has to continue to pay its employees, rather unsurprisingly. It has to make redundancy payments. And then from my perspective, this last one is probably the most surprising or most significant. The company has to continue to pay debts or other liabilities arising under a contract or instrument involving financial services. And Schedule ZA2 sets out in great detail what these sorts of contracts are. And it's extensive. It includes loans, guarantees, securities related transactions, any sort of derivative you can think of, so forwards, futures, options, swaps on almost any underlying, so commodities, interest rates, foreign exchange, emissions, weather, credit. Basically, I would start off with the assumption that if it's a financial contract, you're probably, as a company in a moratorium, going to have to continue to pay it and then go back and check Schedule ZA2. It's all set out in great detail. But other than those debts, if it's a pre-moratorium debt, you have a payment holiday as a company in a moratorium. The company generally has to pay its moratorium debts. So it has to pay those debts that are allowing it to continue to trade while the moratorium is in place. If moratorium debts or the pre-moratorium debts that aren't subject to a payment holiday aren't paid during the moratorium, the creditor can't enforce, but the monitor is supposed to bring the moratorium to an end if he or she thinks the company can't pay those debts. So the creditor can't do anything apart, I suppose, from get in touch with the monitor and start complaining vociferously. But, and this is absolutely crucial, if those debts aren't paid and the company enters a liquidation or administration within 12 weeks of the end of the moratorium, those creditors get super priority ranking. So they leap ahead of the expenses, floating charge holders, preferential creditors in any subsequent liquidation. Obviously, they don't go ahead of the fixed charge creditors. But there's a real incentive, therefore, if you're a creditor and you think the company is viable and it's just having a bit of a hard time that it can trade out of, there's a real incentive to keep supporting that company through this moratorium if you think that it can survive, because your debt will take priority in a subsequent liquidation. In terms of other effects, they're probably the sort of effects you'd expect from an administration sort of moratorium. There are restrictions on winding up an administration. Only directors can present a winding up petition. Only the directors can start an administration. Actually, I think the Secretary of State can still present a petition in respect of public policy grounds. There are restrictions on enforcing security over company property. So you can't simply enforce your security. There are exceptions, they're set out in detail in section A21, and they include financial collateral arrangements, which depend on all sorts of definitions in FSMA, for example. I should also say that as a landlord, you can't exercise a right of forfeiture without the court's permission. You can't repossess goods under hire purchase agreements, again without court permission. Unsurprisingly, you can't start or continue legal process without court permission. And you can't do anything that's going to crystallise a floating charge. But it's not all bad news for creditors, because there is no effect on a contractual right of set-off. So if you're a creditor, you've got a contractual right of set-off, you can still exercise that throughout the moratorium. So just to round it all off, how does the company get out of a moratorium? Well, the time limit could simply expire. There might be a court order. For example, the monitor may decide that they need to end the moratorium if it's not working. There might be a consensual debt restructuring, either with some or all of the creditors, or a scheme of arrangement. Or there might be a company voluntary agreement, an administration, or a liquidation, so a traditional, more formal insolvency procedure. So with that, I'm going to hand over to Jeremy, who's going to talk about the contractual changes that CIGA introduces in respect of supply contracts.
Thanks, Emily. Thank you. This is quite a radical provision of CIGA, in the sense that insolvency lawyers generally in England are not in the business of negotiating contracts that have been formed before the insolvency. And this provision actually trespasses onto the substantive rights of the clients. It was originally floated, I think about 3 years ago, in a working paper, and then rather went on the back burner, I understand, because Parliament was busy negotiating exit from the EU. But it made a reappearance in the guise, or under the guise, of the CIGA provisions, and is quite radical in its scope. There are two fundamental provisions in relation to ipso facto clauses. Before dealing with them, what is an ipso facto clause? It's a rather not happy phrase, but to the English lawyer, it usually means one of two things. Firstly, it can mean that in a contract, if a counterparty enters into insolvency, the contract can automatically terminate. Or more commonly, in my experience, if a counterparty enters into insolvency, the solvent party has an option to terminate the contract. So that's what an ipso facto clause is. What section 233B of CIGA provides is that if there's such a provision in a contract for supply of goods and services, it shall cease to have effect if upon a company entering into a procedure, an ipso facto clause is provided for. So if you have an ipso facto clause with your counterparty, and your counterparty goes into an insolvency procedure, then you can't use the ipso facto clause to either say the contract is automatically terminated or say that you're entitled to terminate the contract. There's an anti-avoidance provision as well that says that if there's something in your contract which isn't strictly speaking an ipso facto clause, but allows for other thing to take place on the event of insolvency, that also will be denuded of its effect. And I'll discuss that a little bit more in a while. So that's the first substantive provision. Ipso facto clauses in the contract for supply of goods and services is, as a starting point, will be ineffective upon the counterparty going into an insolvency procedure. The other less commented upon part of the new provision is that if you're a supplier who has a large amount of, say, trade debt with a counterparty under a contract to supply of goods and services, you can't insist on being paid the arrears as a condition for continuing with the supply. That is quite a radical provision when one thinks about it, because the first thing most business people would do upon hearing that there's a counterparty has gone into insolvency says, well, I'm more than happy to pay you on a COD basis, but only if you pay my arrears before you do that. That is prohibited under the Act. What is an insolvency procedure? Because the provisions only apply if the counterparty goes into an insolvency procedure. Well, there are a number of insolvency procedures defined in the Act. The first is the new moratorium procedure that Emily has just spoken to. The second is an administration, unsurprisingly. CVAs and liquidations get a mention, and also the new restructuring plan gets a mention. That's a sort of scheme of arrangement light, which unfortunately we don't have time to touch upon today. So that is the insolvency procedure. Now, having set out its stall very widely in respect of contracts for supply of goods and services, then the Act takes the next step of excluding or carving out certain types of contract from the wide definition. And some of these carve-outs are extraordinarily wide and will have some impact on, I expect, many of your clients going forward. The first and most important possibly are certain loan agreements, commodity contracts, certain master agreements, including the usual ISDA forms, and derivative and spot contracts. So for a lot of commodity lawyers, hopefully, at least from the perspective of the solvent counterparty, they will not be impacted at all by this provision. There are unsurprisingly certain sectoral exclusions, not dissimilar to those set out by Emily in her talk, including insurers, deposit-taking banks. Very generally speaking, that's because they have their own sui generis insolvency regime. Interestingly, or at least moderately interestingly, one of the few changes from the introduction of the bill in Parliament through to its coming into force was the addition of a carve-out for aircraft liens under the Cape Town Convention, which I understand was a result of quite heavy aviation lobbying. So if you're an aviator with a lien which is enforceable under the Cape Town Convention, that is not included under the scope of the Act. And then, potentially very importantly, there is a temporary exclusion for counterparties who are come within the definition of a small company supplier. That's a slight misnomer because that definition doesn't include, I would argue, some moderately sized businesses. But if your client fulfills one of the two of the following three conditions until the 30th of September, it will not be impacted by this Act. And those three conditions are turnover of not more than £10.2 million, a balance sheet of not more than £5.1 million, and no more than 50 employees. So you have to show two of those conditions, and then you can your client will not be impacted by this Act, but only up until the end of September. After that, the exemption falls away. The next point is the scope of the provision. Now, what does it do other than denude the ipso facto clause? Well, it does two very important things. The first is that it does not preclude other grounds for termination, but only if they arise post-commencement of the insolvency. So if your counterparty enters into an insolvency procedure, you don't use the ipso facto clause because you can't, but if there's a breach of some other term, which is not an ipso facto clause, that may give rise or will give rise to a right to terminate. So the scope of the Act doesn't affect those clauses, but they have to be grounds which arise after the commencement of the insolvency proceeding. The flip side is a radically large provision, I would argue, which is that any right of termination under the provision of the contract that arises before the commencement of the insolvency procedure is also denuded. So to put it more colloquially, this is a use it or lose it provision. If you have any right of termination under the contract, which is exercisable before the company enters into the insolvency procedure, if you don't use it, before your counterparty goes into the insolvency procedure, you lose it. And that is quite a radical act because it doesn't have to be a right of termination related to insolvency, cash flow, or anything. It's any right of termination under the contract. The quid pro quo is that if you're effectively forced into continuing to supply an insolvent party, then your debt should be an expense of the procedure, the insolvency procedure, ranking ahead of most pre-insolvency debt and floating charge claims. Now, you might argue that's all well and good if there's enough money in the insolvency pot to meet those expenses, but if the company is denuded of all funds, that might be called comfort to some suppliers. A few observations. The first observation is that although the Act is radical from an English perspective, it's not so radical for those lawyers on the other side of the Atlantic in the States and Korea, I believe Australia as well, where ipso facto clauses are often prohibited from being exercised at all in executory contracts for any contract. The scope of the English legislation is restricted to contract for supply of goods and services. So that's, if you're an American lawyer used to Chapter 11, that is a radically narrower effect on the provision. Another curious point for commercial lawyers, I suspect a lot of shippers, is that the meaning of termination under the provision of the contract is also unclear. For instance, if you could pre-insolvency have accepted a repudiatory breach as a matter of common law, does that fall under the use it or lose it provision? Or if it's unclear when the grounds for a repudiatory breach arose, both or either before or post-insolvency or upon insolvency, query whether or not CIGA covers those types of termination of common law. If you push me, I suspect they don't, but no doubt the courts will tell us in due course. You also remember that there was an anti-avoidance provision that said that any contractual provision that allows you to do any other thing, allows any other thing to take place upon a company entering into insolvency proceedings is also denuded of efficacy. The any other thing is a very broad term, and as far as I'm aware, is not something which has been used in any other similar or analogous statute. So that's going to, I suspect, cause a lot of litigation in the near future. Does that include, for instance, acceleration clauses? Are they something that's going to be denuded under this provision, or default interest provisions, or possibly even the enforcement of ROTC clauses, which crystallise or become enforceable upon the insolvency? We just don't know, and no doubt that will be a matter of quite interesting litigation in the near future. The next point is, what do you do if you're faced with a counterparty that is relying upon this new provision? Well, the options are actually very limited. The first is asking the consent of the office holder or the company, depending on which insolvency procedure you're in. But if they say no, as I suspect they will, then your only other option is to go for a court order. But the court's jurisdiction in this respect is actually quite limited. Unlike, say, the consent you need to continue against an insolvent company in an administration, continue litigation, there's not a jurisdiction at large. The court is restricted to allowing a disapplication of the provision upon a showing of hardship under section 233B of the new Act. Unhelpfully, perhaps hardship is not defined, although when one reads the government's note, it seems to be something more than an inconvenience, unsurprisingly. So it'll be interesting to see how the judiciary approach this relatively novel concept. The next point is a tricky point, and one which will have, I suspect, some impact on many of your clients' business going forward, which is the extraterritorial effect of this provision. Now, the first thing to note is that the Act, not uncommonly with most English Acts, is silent on the question of whether or not it has extraterritorial effect. But there are some potentially difficult conflicts of law points. I suspect the paradigm example, and that will be an easy one, is where you have two parties applying English law and they are suing each other in an English or London-seated arbitration. Now, in that instance, it would be relatively clear that as a matter of substantive law, that the party who's suing, say, for damages on the basis of an ipso facto clause won't get very far. But it does get more complicated. What happens, for instance, if you have an insolvent counterparty being sued in London, but it enters into insolvency, say in Korea, and has its Korean insolvency recognised under the cross-border insolvency regulation? Could that be a case where the foreign representative of the insolvent party can say, well, I want to exercise a relief available to me under the English insolvency legislation, and argue that the ipso facto clause is something which is just not enforceable as a matter of English law and as a matter of the lex arbitrary, for instance. And that will be a difficult point. Some of you of a certain age will remember that the argument was run in the case of Pan Ocean in 2015, where Mr. Justice Morgan said that ipso facto clauses can be enforced in England, irrespective of whether or not a foreign insolvency law says they're prohibited. In that case, it was, I believe, Korea. But I think it's very serious doubt if that case came before the courts now, whether or not the same result would arise. So if you're in a long-term contract with freightment or charter party, if a counterparty goes bump, you should look long and hard at the charter party form and take a view before you do anything precipitate in terms of terminating the contract and looking for damages. And that is the end of my talk. I'm going to pass over to Nicola Alsop.
So I'm going to speak about the changes that CIGA has brought about to the use of statutory demands and winding up petitions and orders in the context of corporate insolvency. And I'm going to start just with a very brief recap as to the role of the stat demand in corporate insolvency, because the insolvency lawyers that are watching will know that, of course, a stat demand is not a prerequisite to a winding up petition. A company will be deemed unable to pay its debts if it has failed to comply with a statutory demand, but there are at least two other gateways to a winding up order being made. The winding up order can also be made if it's proved to the satisfaction of the court that a company is unable to pay its debts as it falls due, and in addition, if the court is satisfied that the company's assets is less than the amount of its liabilities. Now, in my experience, statutory demands were not particularly popular in corporate insolvency before CIGA came into force. A pre-action letter would work just as well. And I wonder now, given the restrictions we're about to see, if this will be the end of stat demands in corporate insolvency. So what are those restrictions? Well, these are temporary measures, but CIGA allows them to be continued beyond the 30th of September for a further 6 months if the Secretary of State deems that necessary. Given what we're being told about a potential second wave of coronavirus, and in fact the state of the economy at the moment, one might expect that they will be continued, but we'll have to wait and see until closer to the time at the end of September. These measures have retrospective effect, although the Act didn't come into force until the 26th of June. These are deemed as having come into force on the 27th of April. But significantly, the restriction is, as said in the third bullet point there, that no winding up petition can be presented based on any statutory demand served between the 1st of March 2020 and the 30th of September 2020. There is no exception. So we're about to see in the context of winding up petitions that there is a coronavirus test exception, but this doesn't apply in the context of statutory demands. And so, quite frankly, statutory demand served between that period, 1st of March and 30th of September, is pointless. Turning now to winding up petitions and the restrictions placed upon the presentation of petitions by CIGA, this too is a temporary measure, but it also has retrospective effect. This part of the Act is deemed as having come into force on the 1st of March 2020. The accreditor may not present a petition unless it has reasonable grounds for believing that the corona test is satisfied. What's the corona test in this context? It is that COVID-19 has not had a financial effect on the company, or the grounds would have arisen even if COVID-19 had not had a financial effect on the company. And I'm going to come on in a moment to discuss how that test may be satisfied. But first, let me show you that this test also applies where a creditor wishes to present a winding up petition on the basis of cash flow or balance sheet insolvency. So the test is not limited to presenting a petition based on a stat demand. It has wider effect than that. So what are the salient features of the coronavirus test in this context, and when is it likely to be satisfied? In terms of presenting a petition, it's clear from the wording of the schedule that the burden is on the petitioning creditor to advance reasonable grounds for believing that coronavirus has not had a financial effect on the company, or that the company would be insolvent absent coronavirus. Now, one can readily see that that's likely to pose significant challenges, given that the petitioning creditor is unlikely to have access to the debtor company's financial information. Further, financial effect appears to create a low threshold. It's defined in paragraph 21 of Schedule 10, which says that coronavirus has a financial effect on a company if and only if the company's financial position worsens in consequence of or for reasons relating to coronavirus. And so you can see from that wording, relating to coronavirus, that the scope is really quite large. When's the test likely to be satisfied? Well, my view is that it's going to be a rare situation that the petitioning creditor has reasonable grounds for believing that the coronavirus has not had a financial effect on the company. Maybe Amazon has had seen benefits from the coronavirus, maybe a courier company has been unaffected, but for the large part, I would expect there to have been a negative financial effect by reason of the coronavirus. It's likely that the petitioning creditor is going to find it easier to fulfil the second limb. That's that the company would have been unable to pay the petition debt even if coronavirus had not had a financial effect on the company. In this regard, the key factor is likely to be timing. If the debt arose before the effects of coronavirus took hold, that provides a good basis for saying that the company was unable to pay its debts, notwithstanding COVID-19. There hasn't been a significant amount of case law yet on CIGA, as one might expect, but I'm aware of 3 cases that were decided before the Act was brought into force, but did consider the terms of the bill, which are in substantially the same form. For the large part, those cases were considering the extent to which the court ought to have regard to new legislation which has not yet been enacted, but which might be enacted in the near future or would be expected to be enacted in the near future. But it's worth at this stage talking about the decision of Insolvency and Companies Court Judge Sally Barber, which was handed down on the 16th of June, because that contains some useful guidance as to when the coronavirus test might be satisfied. In that case, a winding up petition had been presented on the 1st of May this year, relying on a stat demand served on the 27th of March. The case concerned an unpaid loan, and the judge held that the petitioning creditor could satisfy the second limb of the test. That was on the basis that the loan was due for repayment long before the pandemic hit. So, as I said before, timing is likely to be crucial in that regard. The company had historically, following the loan coming due for repayment, agreed to make scheduled interest payments, but it had defaulted on those interest payments, which suggested a pre-existing cash flow problem. And it was not until the 16th of April 2020 that the company wrote to its creditors, blaming its financial problems on the pandemic. So on that basis, it was found that the petitioning creditor was entitled to present the petition. However, that's not the end of the matter. You can see from the final bullet point on that slide there that there are parallel restrictions on the making of winding up orders, and those are to be found in paragraphs 5 and 6 of Schedule 10. And if you consider the provisions of paragraph 5, it applies where 3 factors are present. The first is that a petition is presented between the 27th of April and 30th of September this year. The company is deemed unable to pay its debts. And thirdly, it appears to the court that coronavirus has had or had a financial effect on the company before the presentation of the petition. Now, in relation to the third of those requirements, that hurdle is on the company, and it's for the company to demonstrate that coronavirus had a financial effect on the company. However, that's a low threshold. And if you read the decision of Judge Barber in the Rhea Company case, she said that this is a low threshold because the requirement is simply that a financial effect must be shown. It's not a requirement that pandemic be shown to be the or even a cause of the company's insolvency. Moreover, the language of the provision requires only that it should appear to the court that coronavirus had a financial effect on the company. And that's in contrast to other parts of the schedule, including paragraph 5, which requires the court to be satisfied of given matters. And taking all this into account, the test that she applied is that the company must be able to establish a prima facie case rather than to prove that the financial effect relied upon on a balance of probabilities. And so if those 3 factors are present under Schedule 5, there is then a restriction on the making of a winding up order. And that restriction is that the court will only make a winding up order if it's satisfied that the insolvency ground relied upon would have arisen even if coronavirus had not had a financial effect on the company. So at this stage, when the court comes to consider whether or not to make an order, we are no longer in the territory, unsurprisingly, of the petitioning creditor's belief or the reasonableness of that belief, but rather the burden at the winding up order stage is on the petitioning creditor to show that even if the financial effect of coronavirus is ignored, the company would still be insolvent. How does the petitioning creditor go about demonstrating that? Well, obviously, we've got the timing point, but the facts of Ria Company, to my mind, really demonstrate how hard it's going to be to obtain a winding up order in light of this test and the amendments made by CIGA. So in that case, the evidence was consistent with the company being insolvent pre-COVID. As we've heard, it was unable to repay a loan which fell due for repayment long before the pandemic hit. However, there was also evidence before the court that the company was seeking to refinance as at the end of 2019 and the beginning of 2020. And the judge noted that that refinance had been stopped in its tracks by the pandemic, and therefore it could not be said that the company would have been insolvent even if coronavirus had not had a financial effect on the company. And quite simply, the funding drive may have meant that the company was not insolvent, it had been able to repay its debts. So, to my mind, one can readily imagine examples where a company was unable to pay its debts pre-COVID, but was seeking to restructure or refinance. And if such refinance had been successful, it would then have been in a position to pay its debt. But unfortunately, due to the pandemic, such refinancing did not come to fruition. And it seems, based on those facts, that the petitioning creditor would not be entitled to a winding up order. I'm going to turn in a moment to just talk briefly about the procedure now under CIGA. But before I do that, it's also worth noting one further provision of substance, and that's paragraph 7 of Schedule 10, which applies where a winding up order was made between the 27th of April and the 25th of June 2020. If that winding up order would not have been made because the coronavirus test would not have been satisfied, the order is regarded as being void. Now, that's a bold provision for at least 2 reasons. First, it seems to have automatic effect, and so it's regarded as being void without a court order to that effect. Secondly, there doesn't seem to be any carve out. So unlike section 127, for example, where a transaction is ordered void unless the court orders otherwise, this is simply void ab initio, full stop. It's difficult to see how this particular provision is going to play out in respect of those winding up orders made in that period, because there's nothing in the schedule to say what's going to happen to the OR and the liquidator's costs. There's nothing to say what's going to happen in respect of transactions that have been entered into in that period. So we may well see some difficult applications to the court to gain clarification in that regard. One further important point of substance, that's that Schedule 10, paragraph 9, has amended the commencement date of winding up proceedings. So previously, a commencement of winding up was taken to be on the date of the presentation of the winding up petition. Under paragraph 9, it now commences on the making of the winding up order. That's likely to have at least 2 effects. The first is that there's no longer going to be a need for an application under section 127. Previously, when a petition was presented, led to bank accounts being frozen and the company having to apply to the court to validate certain dispositions of property. That won't be necessary now in light of that amendment. But also, it seems that the date for antecedent transactions, that's transactions at an undervalue and preferences, will now be on the making of the order and will no longer be backdated to the presentation of the petition. In terms of the procedure, I would urge everyone to read the new Insolvency Practice Direction, which was published on the 3rd of July 2020, which contains some very useful guidance. There may well be differences in approach across the courts. Some things, though, will be dealt with in exactly the same way in all courts. In particular, all petitions now must include a statement regarding the coronavirus test. Petitions will initially be in private. So although they can be served, they must not be advertised, and they will not be available for inspection on the court file, which marks a big change in procedure. The procedure also is really quite drawn out now post CIGA. So practice directions suggests that there will initially be a review of the petition on paper when it's sent to the court. At that stage, the court might decide not to allow it to be presented, so not issue it, because, for example, it does not include the statement regarding the coronavirus test. It's only if it's satisfied that it complies with those new requirements that it will allow it to be issued. It will then have to be served on the company, and there will then be a pre-trial review. In London, this is likely to be a non-attendance pre-trial review. And at that pre-trial review, the court will either decide if it thinks that ultimately a winding up order is going to be made and there's no opposition from the company, to place the petition into the general winding up list. Alternatively, if it's not satisfied that a winding up order is likely to result, or there is opposition from the company, it will then list the petition for a preliminary hearing. It may well give directions as well as to the evidence to be filed and served in the context of the preliminary hearing. The petition will then come before the court on that preliminary hearing, at which stage the company and the petitioning creditor may well be represented. There's likely at that preliminary hearing to be an argument as to whether the coronavirus test is satisfied or will ultimately proven to be satisfied. If the court is satisfied at the preliminary hearing that it's likely it will be able to make a winding up order having regard to the coronavirus test, it will put the winding up petition in the winding up list. If it's not so satisfied, it will dismiss the petition at that stage. If it puts it in the winding up list, it's only at that stage that the petition will be advertised. And then it will appear in the winding up list in due course. The 2 points I take from this is that it's going to take an awful long time from presentation to the final determination of this petition, and certainly far longer than it did pre-CIGA. And the second point, do not advertise until the court gives you permission. That's a significant difference in procedure. That's all I've got to say on those amendments. I think we're hopefully going to take some questions now. So I'm going to stop sharing my screen and hand you back to Stephen Baister. Thank you.
Right, thank you very much, Nicola. We have some questions. The first one's deceptively simple. It's probably for Emily, but I suppose anyone should feel free to chip in. And it's because it's stressed the panel, what is the panel's view as to whether the moratorium can be excluded by contract?
So my view is it probably can. Jeremy, do you?
I'd have to check the case law, but I'd be surprised if a floating charge holder could exclude the effect of the moratorium, because that would potentially rejig priorities among securities. So very provisionally, I think that probably would be at least naughty and possibly without effect.
I suppose you wouldn't be ousting the jurisdiction of the court, would you? Because it's not a court process.
Yes, that's a point. I suspect maybe what would happen, I don't know what you think, Stephen, is that if you wanted to rely on that, it may require an application to court to get at least clarification.
Yeah, okay, well, it's a good question, and that's a nice, straightforward couple of answers. I'm going to move on to get through as many as we can. Slightly longer one. If a right to terminate a construction contract due to insolvency of the contractor is denuded, but the contractor does not continue to perform post-insolvency, would the failure of the contractor to perform post-insolvency give a freestanding right to termination that would not be denuded? Have you got that? Or do I need to do it again? I'm not sure I've got it. I think I see what's being got at there.
Yes.
I want to have a go at this, Jeremy.
Yes, I think I will. I think the answer is probably yes, for two reasons. As you'll recall, if a right to terminate arises after the entry into the insolvency procedure, you can exercise that right. So that could be a breach of a condition or a repudiatory breach of an innominate term, of which I suspect will be plenty in your usual construction contract. So that's the first point. The second point is if the insolvent counterparty is moribund, so it's crystal clear that it cannot perform its contract under the terms of the contract, I think there'd be a jolly good shout for saying that that's a renunciation of the contract, and that it is not, when you accept the renunciation of the contract, a termination under the provision of the contract of supply of goods and services, but a termination at common law. My second answer is slightly tentative because, as I said in my talk, it's not entirely clear if the draftsperson of the legislation wanted to exclude common law rights of termination or not.
Right, thanks very much. Does anyone else want to chip in before I move on, or you're going to leave that one with Jeremy's?
No, I'm happy to leave that with Jeremy. I think that was a good question.
I entirely agree with him.
Thank you. You're very
Okay. I'm going to thank Elaine O'Connor for the first question and Paul Scott for the second, because they've both owned up and should be credited. The third one is anonymous, because I suspect it's a shameless attempt to get some free legal advice on how to make some money, but it's a jolly good question. And it's this: would you say that we need to adjust standard boilerplate insolvency termination clauses, both from the perspective of a supplier and that of the customer? To which I think the answer is obvious. But if so, we'll ask, do you have any drafting tips for commercial lawyers, please? In other words, could they please have a free clause that this?
Nicola, that must be for you, surely.
Who wants to take this one?
Jeremy, do you think that they could draft it in such a way that it didn't seem to be an ipso facto clause? So could pin it on something else which stood outside of the insolvency regime to make it survive? Would that be?
Well, yeah, I think that the any other thing to take place provision is probably directly aimed at clever draftspersons trying to get an ipso facto clause effect indirectly when directly it would be prohibited. But leaving that drafting point aside, I think there's going to be a wider effect on the market because of the use of the lose it provision. Suppliers, I'm pretty sure, want a heads up as to better heads up as to when a counterparty is going to go bump. And there are obvious ways you can do that. You can narrow the payment terms so you get paid within, say, a week rather than a month. You can make timers of the essence for payments so that if someone's a bit slow, you have the right to terminate before the counterparty goes into an insolvency provision. So I suspect the answer is there will be drafting provisions, which I haven't given a great deal of thought to. But I think on the market terms, I think suppliers at least will be wising up so that you have early warning signs of a counterparty going into insolvency. Because what you don't want to do is end up in a situation where you're stuck with your insolvent counter supplier, because although obviously your moratorium debts or your debts post insolvency procedure rank very high up the chain, as we all sadly know, sometimes even if you're a super priority creditor in an insolvency, you still get pari passu. You still can get very little once the assets are all divvied up.
Could we just take a couple more? One is perhaps, I think, for Emily. The moratorium is concerned with the rescue of the company as a going concern, as opposed to administration, which was traditionally focused on the rescue of the business, wasn't it, as one of the hierarchical objectives? I mean, what do you think is the thinking behind that? Because it's much more difficult to rescue a company as a going concern than it is to rescue the underlying business.
That is a very good question. Perhaps rather shows my skepticism here. It may just be a drafting issue because this legislation has been rushed through.
Yeah.
But I agree with you. It's much more. It is much more specific than saving the business, and it does suggest. I mean, it simply suggests to me that what they're looking at is the administration procedure is obviously you can engage in pre-packs and try and rescue the business that way, but this is very much more about the survival of the entity. I'm not sure that I'm saying a great deal that makes a lot of sense there. But
it's a terribly unfair question because
it's a great question.
A technical question, but it's very striking, isn't it? And it may be that the cock-up theory is the correct theory.
Well, it certainly was rushed through, this piece of legislation. For something that's such a large piece of legislation, I can only see work for all of us on the horizon, which is not necessarily a bad thing from a selfish perspective.
Yes.
Yeah, that's a very good question.
Does anyone want to chip in with one final question before we close for the day? It seems not. I think I've covered the ones made. So I'm going to end by thanking all of you for a very interesting exposition of not the whole of it. Perhaps there'll be something else later on the many provisions of this chunk of legislation we haven't been able to cover. So thank you all of you for a splendid outline of what you were able to outline, and thanks to everybody who attended. I think the one thing that's clear is that there's going to be loads of work arising from all this. I suspect we're all particularly looking forward to the slew of contradictory cases about the wrong paperwork being filed to get a moratorium, and whether it's valid in the circumstances or not. We seem to be making money for the bar and for some, I don't know, the last 10 years now. But thank you all very much. Thanks to everyone for listening. And I think, Sarah, who's monitoring that, we're at an end unless anybody's got anything to add. Thank you so much. And good evening or whatever it is to everybody.
Thank you.